Hello, my name is Carla from Homecare Realty. Today, we will be answering some questions regarding property management. Question 34, FAQ. One of my roommates is moving out and we don't have anyone new to move in right away. Is he still responsible for his share of the rent? Yes, your roommate is still responsible to pay his share of the rent. You and your roommates are all bound jointly to pay the rent to your landlord. If a roommate leaves, the rent must still be paid in full. The landlord can evict you if the rent is not paid in full, regardless of your roommate moving out. Your roommate may beg the landlord to remove him from the lease. If you and your landlord agree to this change, then the roommate will no longer be responsible for any of the rent. This new agreement should be in writing and everyone should sign it to avoid later difficulties. As a tip for next time, it is often a good idea to have a roommate agreement in place with all the people you are living with. The agreement should specify how rent will be paid, how long each roommate remains responsible to pay their share of the rent, what will happen to rent payments if a roommate leaves. Question 35, FAQ. I live with my landlord and we keep arguing about everything. What can I do? If you share living space with your landlord, then the Residential Tenancies Act does not apply. For example, the RTA does not apply when you rent a room in the landlord's home. Likewise, it does not apply if you share a kitchen and/or living room with your landlord. If you and your landlord have a problem, the first step is for you to communicate about the situation and try to work out a solution. If you reach an agreement, make sure it is in writing. It is important to document problems and their solutions in case you need to take further action. Question 36, FAQ. What can a tenant do if the landlord won't fix anything? The tenant should let the landlord know about the problem in writing. The letter or email will provide proof that the tenant requested the repairs if there is a dispute later on. If the landlord does not complete the repairs, the tenant has a few options. The tenant could complete the repairs and then request reimbursement from the landlord. The tenant could also apply to provincial court or the Residential Tenancy Dispute Resolution Service for a rent abatement. If the repair involves a matter covered by the minimum housing and health standards, then the tenant can contact the nearest Alberta Health Services, Environmental Public Health Office, or call HealthLink at 811. The tenant could provide notice to move out if he or she is in a periodic tenancy. The tenant could apply to terminate the tenancy early if he or she is in a fixed-term tenancy. Question 37, FAQ. Can a tenant stop paying rent while waiting for repairs to be done? No, even if repairs are not complete, a tenant must continue to pay all the rent on time and in full. If a tenant stops paying rent, can be evicted. If a tenant moves out during repairs, the tenant can talk to the landlord about reducing rent for this period. The tenant may want to talk to the landlord about extra costs, example, accommodation, eating out. If the landlord agrees to reduce the rent, pay for any of the tenant's expenses, the landlord and tenant should get the agreement in writing and sign it. Without such an agreement, the tenant should keep paying rent in full. If the landlord will not voluntarily agree to reduce the rent and the tenant thinks that the landlord has interfered with their right to enjoy living in the property, then the tenant could apply for a rent abatement in provincial court civil or through the Residential Tenancy Dispute Resolution Service. If a disaster, example fire, flood, destroys the property, it is likely the lease is frustrated. This means the lease is unable to continue and the agreement will be over. But if premises can be repaired, it is likely the lease will be able to continue. Question 38, FAQ. If a tenant completes repairs, can he or she bill the landlord? It depends on the circumstances of the situation. It is more likely a tenant will be reimbursed if the repairs were clearly the landlord's responsibility and the tenant can show the landlord was informed of the need for repairs, but the request was ignored. If the landlord refuses to pay the tenant for the cost of the repairs, the tenant could make an application to get the money back in provincial court civil or through the Residential Tenancy Dispute Resolution Service. The judge or tenancy dispute officer who hears the matter will decide if the tenant should be reimbursed based on all of the evidence brought before them. Question 39. FAQ. Is a landlord allowed to make frequent and disruptive repairs? Tenants have the right to peaceful enjoyment of their property. Landlords have an obligation to ensure tenants receive that right, along with the obligation to provide a property that is safe and habitable. With repairs, the rights of both the landlord and tenant have to be balanced against one another. It is possible that by continually arriving to carry out repairs, the landlord is breaking their obligation to allow the tenant to live in peaceful enjoyment. On the other hand, if the repairs do not get completed, the landlord may be breaching their other obligation to provide a safe, habitable rental property. If the tenant thinks the landlord is being unreasonable, the tenant should talk to the landlord about the situation. If an agreement cannot be reached with the landlord, the tenant may want to consider applying for a rent abatement or to end the tenancy on the basis that the landlord is not allowing for peaceful enjoyment of the property. These applications can be made in provincial court civil or through the Residential Tenancy Dispute Resolution Service. If the property is not safe to live in because of the repairs being made, the tenant could contact Alberta Health Services, Environmental Public Health, or HealthLink at 811 for more information on property inspections. Question 40. FAQ. Who is responsible to treat bugs in a rental property? The landlord has an obligation to make sure the premises always comply with public health requirements. Under the minimum housing and health standards, the landlord must ensure the rental property is free of insect and rodent infestations. Tenant is required to keep the property reasonably clean, to allow entry for any pest control treatment, and to follow the instructions of the exterminator. If a tenant thinks they are having pest issues, the tenant should notify the landlord about the problem in writing. If the landlord ignores the problem, the tenant can contact Alberta Health Services, Environmental Public Health, or call HealthLink at 811 to speak with a health inspector. If a health inspector investigates and finds there is an insect or rodent infestation, the inspector can order the landlord to fix the problem. If the landlord ignores the order, the tenant can either apply to provincial court or the Residential Tenancy Dispute Resolution Service to end the tenancy, or serve the landlord with a 14-day notice that he or she is going to end the tenancy. If the landlord believes the tenant should pay for the treatment, then the landlord may issue a bill to the tenant, or may deduct the cost of the treatment from the security deposit. If the tenant refuses to pay or applies for a return of the security deposit, then the landlord will have to bring evidence to show that the tenant did not follow the exterminator's instructions. The judge or tenancy dispute officer will decide who should have to pay based on the evidence that is before them. Question number 41. Does a landlord have to paint between tenants? No, a landlord is not obligated to paint between tenants. The landlord is obligated under the minimum housing and health standards to ensure that walls and ceilings are in good repair, with no cracks or holes, and that they are easy to clean. In the bathroom, the walls must be smooth and non-absorbent. In the kitchen, the walls must be in good condition to ensure that bacteria and pests do not become a problem. These requirements mean that while a landlord does not have to paint between every tenant, the landlord does have to ensure that painting is done on a regular basis to meet health standards. Question 42. FAQ. Can the landlord change the locks? No, the landlord cannot change the locks without providing the tenant with a key immediately. If the landlord locks the tenant out, the landlord has committed an offense under the Residential Tenancies Act and could face a fine of up to $5,000. Tenants can file a complaint with Service Alberta if this happens to them. Question 43. FAQ. What happens if the tenant does not object and does not move? The landlord can apply for an order to terminate the tenancy and get back possession of the property. They can do this through the Residential Tenancy Dispute Resolution Service Civil. When the landlord applies for this order, the tenant will be served with new documents from the landlord. If the tenant does not move after being served the order, the landlord may hire a civil enforcement agency to evict the tenant. A civil enforcement agency bailiff can then come to the property, remove the tenant and any of the tenant's belongings. Only the bailiff has the power to physically remove the tenant and the tenant's belongings. The landlord cannot remove the tenant themselves. If you have any questions, feel free to contact HomecareRealty. Thank you.